number 57.
Good morning, Your Honors. May it please the Court. This case is about the validity of covenants and the entitlement of a party who has obtained those covenants through free and fair contractual negotiation to retain the benefit of their bargain. The Court of Special Appeals said that the standard for making this determination is whether the beneficiary of the covenants can prove that with a reasonable probability that the property owner over whose actions the beneficiary has no control will develop the property according to a particular vision, in this case a vision that the Court of Special Appeals apparently gleaned from extrinsic evidence. The standard should have been, given that the covenants were duly executed and recorded and binding on the property in question, and there wasn't any dispute about that, can the property owner who's seeking to invalidate the covenants prove that there's been a change in circumstances affecting the property itself and not affecting the property owner that is so complete and radical as to cause the restrictions gleaned from the unambiguous language of the document to outlive their usefulness. And the trial court found, as a matter of fact, and based on sufficient evidence in the record, that there hadn't been such a change. At the hearing before the Court of Special Appeals, MIE's counsel...
The city is attempting to enforce these covenants by virtue of the fact that an annexation agreement entered into by the property owner of the time
Yes.
contained an agreement that these covenants existed. If it wasn't for that annexation agreement, what right would the city have to enforce these covenants? If the property owner had voluntarily put these covenants on the property and there wasn't any annexation agreement, the city wasn't a part to it, the covenant standing alone would not be enforceable by the city. Is that correct?
It depends on whether, as in this case, the city was the named beneficiary in the recorded document. I think that if the city was the recorded beneficiary and the parties intended that the city be the...
You might have a contractual... It's probably just a matter of academic exercise because there was an annexation agreement.
There was.
The annexation agreement agreed to between the party imposed these covenants. I just am concerned that this case might end up confusing general covenant law because it's an annexation agreement under a practice that's particularly, as I understand it, prevalent in some jurisdictions in the state and not in others.
It seems theoretically possible that that's the case, although I do think in this case the annexation agreement and the covenants were intertwined, but in any event, the covenants could stand separately. They do name the city as an intended beneficiary, and the city gave consideration for that. And your cases recite that the covenants, aside from the fact that the annexation agreement certainly is a contract, that covenants are in the nature of a contract themselves. So since the city gave consideration...
You can't name me many covenant cases involving the city's enforcement of this type of agreement. I don't remember any, but I understand that they're relatively common in some suburban and urban areas, and I don't see anything necessarily wrong with them. I just don't want to get covenant law messed up in the process of resolving this case.
Yes, let's not do that. There are many covenants cases. Obviously, most of them don't involve the city as a beneficiary. They involve the adjacent property owners. But you had the Rylands case, as Your Honor knows, which involved a similar attempt by a jurisdiction to restrict uses on the property in favor of the city.
But isn't there a meaningful difference between the situation of the city of Rockville and Rylands and the city of Bowie here?
Yes, Your Honor. The city of Rockville had zoning authority, and therefore, under Your Honor's precedent, the attempt to use the annexation agreement in that case was unlawful as conditional zoning. But my point is that it's an example of another situation in which a recorded case in which a jurisdiction did use the covenants to obtain concessions from a developer.
It was one of the unusual property cases in which my good friend Judge Harrell and I were not in agreement.
Highly unusual, Your Honor. Okay. The hearing before the Court of Special Appeals, MIE's counsel opened by telling the court that he could summarize the case in 3 words: municipal temper tantrum. It got a laugh from the gallery, but it demeaned not just the parties, but the circuit court and the entire judicial process. This case is about bigger issues than that. I'm not going to recite the facts at length, but just to put the case in context, the defendants in this case, who I'll refer to as MIE, although they've changed their name to St. John Properties, they own a huge 466-acre tract located at the intersection of 50 and 301 in Prince George's County. Like MIE...
Which corner of it is it at 5301?
It's the
Northeast?
southeast quadrant.
Northeast?
I'm sorry, the northeast quadrant. Northeast. Apologize. Directions aren't my strong point.
Northeast quadrant's the dance club case. Is that right? In the northeast quadrant where this is that? Yeah. I thought it was the northeast quadrant.
Yes, it is. Yes,
okay,
yes.
That's
exactly.
Thanks.
So the property has been changed. The name of the property has been changed to Melford, and that is significant because the annexation agreement allows the property owner to do that. So the parties anticipated that the name might be changed for the Maryland Science and Tech Center, and I think that goes to the issue of whether something called the Science and Tech Center was a fundamental understanding of the parties in terms of how the property was going to be developed.
Holding aside for a moment the question of this dance studio, I understand, and correct me if I'm wrong, that your position is that all of the development that has been permitted to proceed on this property is consistent with the covenants. Is that your position, or?
All of the buildings are consistent. There are some other uses that are subject to stayed litigation pending the outcome of this case that the city contends are also unlawful.
Stayed litigation?
Stayed, yes. It's been closed administratively, actually, because this case has been going on for so long. So it's not our position that every use that's in there is lawful, but it is our position that the city has not done anything to waive enforcement of the covenants.
I mean, that was the basis of the question, the argument of waiver.
Yes, I think that that there's been no waiver for a number of reasons, one of which is that the actions that are alleged to have been to have constituted a waiver were largely within the control of the property owner who created those situations and then is complaining to this court that the city tolerated them and therefore waived the covenants.
We have no final decision below on whether or not there has been a waiver of these covenants by virtue of numerous breaches of the covenants. We've had no final opinion indicated below. I'm trying to see whether the cart's up here or the horse is up here.
I'm sorry, Your Honor, I didn't understand the question.
My understanding is that depending on how we resolve this case, there's some other case pending in which somebody's arguing about whether or not the covenants have been waived. Is that true?
No, that was in this case.
But has that issue been stayed in this case? Has it been?
No, that case was resolved by the court. There was found to be no waiver.
Okay.
Well, it was resolved by the trial court.
Yes.
Isn't it the effect of the Court of Special Appeals opinion in this matter to remand it for further evidentiary hearings in the trial court to reopen the notion of whether there has been a waiver by the city or not?
That is one of the points that the city is asserting as error, is the remand for that purpose, because the opinion says that the evidence doesn't establish any waiver, and then says, but since I'm sending it back anyway, you can put on additional evidence when you get back there if you think there's other things that you want to put on. And I think that that was error because the MIE had every opportunity and was permitted by the court to introduce whatever they wanted to introduce concerning waiver. And they, in discovery, had made all kinds of assertions about what constituted waiver, including the fact that the city allegedly permitted a bicycle race on the public streets through the property, and that wasn't permitted and it constituted waiver. So they did have the opportunity to fully develop that point, and they failed to do that, and it's not fair on remand to give them a second bite.
Does this I think is more of a legal question, so it's not, whether the record reflects it or not, you can still answer it. Does the city of Bowie, in its ordinances, purport to exercise any regulation with regard to a building permit within
Yes,
the
sir.
city bounds?
Yes, sir, it does.
Does it have an independent inspector, or does it piggyback on the counties?
Ordinarily, they don't inspect commercial properties. They issue the building permits for the buildings themselves.
They, meaning the city of
They,
Bowie?
the city, I apologize.
So
They-
you get a county permit to build, and you must get a city permit.
Yes. And
What about a use and occupancy certificate?
the city doesn't issue use and occupancy certificates, to my recollection, but they do issue building permits for the build-out for the tenants. And there were no building permits for, as to the best of my recollection, for the tenant build-out for the dance studio, and likewise for the matters that are pending in the state litigation. But because the property owner does not have to come to the city with the leases, the city doesn't always know when there's a tenant in the property for whom a build-out permit has not been obtained.
Is my understanding correct that the major problem that the Court of Special Appeals had with the Circuit Court was they weren't persuaded that Judge Houghton, in applying the law as to whether or not these covenants should be allowed to have continued vitality or not, that she focused too much on whether the original concept of the Science and Tech Center could or could not come to fruition versus a more general approach
I think
of whether or not the property could be meaningfully developed at all.
Well, I think that's what the trial court did decide, that it could be meaningfully developed, and I think the opposite is true, that the Court of Special Appeals was concerned that she failed to focus sufficiently on whether an entity called the Science and Tech Center would be developed, because what the court said was the city will not be entitled to enforce the covenants unless the Circuit Court is persuaded by a preponderance of the evidence that the use of the property at issue as the Maryland Science and Technology Center remains a reasonable probability. The court didn't define what the Science Center was. So if you look at the covenants in your cases, and here I have to apologize for not citing 3 recent cases, including Judge Cathel's opinion in Miller versus Bay City Property Owners, and then 2 cases that were decided after the filing of my original brief, SDC 214 LLC versus London Town Property Owners, and Loudon versus Bowsley, which are both Judge Eldridge's opinions. But you made clear in those cases that if the document themselves are unambiguous, you don't look at extrinsic evidence. And the documents themselves in this case simply have a list of uses that are permitted on the property. That's all. And so the question is, can you develop the property in accordance with that list of uses? And that is not a unduly harsh restriction in these covenants. That list comprised almost the entire list of uses that was then permitted in the zone. The uses that were excluded were uses that the parties agreed weren't appropriate for this kind of business park, airports and things like that. But in general, the list was not particularly onerous, and that's what the covenants say. The covenants is a brief document. I think it's 3 pages, and it says you may put these uses and no others on this property. And that's not ambiguous. You don't go to extrinsic evidence under the cases that you've decided to determine what the purpose of this document was. The covenants and the annexation agreement are entirely unambiguous, and there's never been an argument made that they were ambiguous. Now, the defendants here have conflated 2 issues, and that's whether you look at extrinsic evidence for the issue of determining what the purpose of the document is, and whether you look at extrinsic evidence for the purpose of determining whether there's been a change in the circumstances affecting the property. And the court allowed extrinsic evidence on that second point. on whether or not there's been a change in circumstance. In fact, it allowed evidence that the city would have contended was marginally relevant, but they were allowed to put in anything they wanted on that issue of change in circumstances. But the court properly excluded extrinsic evidence that was designed to explain the meaning of an unambiguous document. And if you look at the record, it's very clear when she excluded something, it predated the annexation agreement, and if she admitted something, it postdated the covenants in the annexation agreement, and it was offered, and counsel repeatedly said so, it was offered for the purpose of explaining primarily the withdrawal of the alleged withdrawal of the University of Maryland from the project, but certainly it went to the issue of whether or not circumstances had changed pertaining to the property. So your cases make clear that was proper, extrinsic evidence on change in circumstances, but they weren't entitled to admit extrinsic evidence on the purpose of the document itself, which was clear and unambiguous that there was going to be a business office park on this property and it was going to have these uses and no others. You have to, I would suggest that the court should consider that the city's investment in this property amounted to millions of tax dollars, and whatever one thinks of the value of the public bonds that were used to finance stormwater management and the roads, because they're going to be recouped through a special taxing district, and so whether you can count that as consideration. There's at least $1 million in city funds, tax funds, that were expended on the extension of water and wastewater facilities to this property that are not going to be recouped through the special taxing district. So the city had a right to rely on the long-term validity of the covenants to bring it its return on investment, the return that it expected. That anticipated return being the development of the property in a way that furthered its economic development interests. And the other point that I really want to make is that the cases make clear, if you look at State Roads Commission versus Rogers, and I think Guilford versus Beasley particularly, they make clear that when you're looking at a change, at whether a change in circumstances, sufficient change in circumstances has occurred, you look at it from whether or not the covenants have been rendered meaningless to the beneficiary. So after the defendants in this case have conflated these two concepts of when you get extrinsic evidence, they then compound that error by saying that you need to look at it to determine whether the covenants are meaningless from MIE's perspective. But that's not the issue. The issue is, have they become meaningless from the perspective of the property owner?
Are these other businesses that are being, or whatever it is that's being conducted on the property already, are they leased or are they owned by other property owners? Have there been sales of parcels of property within this 400 and some acre tract?
There's been at least one sale of a tract in there to the Masonry Institute. For the most part, they are buildings owned by MIE and leased to tenants.
From the beneficiaries of such covenants, and in this case, the city may well be one because of the annexation provision being named, but the beneficiaries are generally any property owner in the future that may own property within. If you have, and I think you have here, the traditional covenants that run with the land. They bind everybody and benefit everybody that ultimately owns the property.
It is conceivable to me that if additional sales of the property are made, but I don't anticipate that like that, it could happen because
Something's going to happen. Whether the property doesn't generally sit around and nothing happened.
There are sites that are going to be sold, most likely. So it's conceivable to me that those property owners could also assert a third-party beneficiary status. Since the city is the named and intended beneficiary in the covenants, I don't think it's entirely clear, but it's conceivable to me that they could, but they would not displace the city as being an interested party in this.
Under these circumstances, may well not, but I'm not so sure that the third-party beneficiaries in the general covenant arrangement. I think they're just beneficiaries, the various landowners that own the property in the future.
That's certainly conceivable.
Refresh my recollection. Was the property rezoned by the county to the EIA zone subsequent to the annexation and execution of the covenants?
My recollection is that it was EIA zone when it was annexed.
when it was annexed?
Yes. Although it would have been shortly before, because I think it was rural tier property.
Okay.
Well, what's now known as rural tier.
Thank you, Mr. Hirsch.
Thank you, Your Honor. Good afternoon. May it please the Court. I'm Charles Hirsch on behalf of the respondents, MIE Properties, which is now known as St. John Properties. Ms. Levan took issue with my summary of this case that I used at the Court of Special Appeals. I'm not exactly sure why. I don't see that it was demeaning. And not only is it accurate to say that we're here because of a municipal temper tantrum, but it really underscores why these covenants need to go away.
What difference does it make whether the city of Bowie has a temper tantrum? When you're
Because,
talking about covenants that run with the land.
because covenants should not be used in a way to exert leverage the way they're being used by the city of Bowie. And there are two reasons
Why not?
that
Why
they
not?
should.
Yeah, that's my
Two
question.
reasons. And they're both the reasons why this court should void the covenants. One has to do with improper zoning.
What zoning?
When you take a large tract of land and say, these are the only uses you can have on
No,
this
they didn't
land.
say it. You said it.
Well, MIE's predecessor may have agreed to it,
Well,
but the zoning laws
And it
have
wouldn't have
changed.
happened, and it wouldn't have happened had they not.
But the zoning laws have changed. So the county has made the decision that more uses are now allowed, but these are
But
frozen in
covenants can
time.
always be more restrictive than zoning.
But the city shouldn't be in a position where it is using the covenants to, in effect, decide what could go in and what can't go in. And I'll give you a good
Suppose you had covenants with other landowners at the time. Forget the annexation.
Okay?
And the zoning changes to now permit something else. That doesn't mean the covenants aren't any good, does it?
Well,
General rule is that zoning and covenants can apply at the same time. The most restrictive of the two is what binds the property.
right.
And your arguing is that because the county has looser zoning, these restrictive covenants shouldn't apply. That's not my understanding of Maryland law.
What it's doing is it's taking the control away from the county. Judge Wilner's example, when it's two private parties, that's a completely different situation because you don't have a municipality.
What's the difference? It's maybe even worse to have a private citizen take the authority away from the county if that's the way you're looking at it.
Well, I would disagree in that what you have is a municipality now making decisions what can go into a certain property and what can't, and am I going to change it or am I not going to change
now,
it?
no, they're trying to enforce covenants that were entered into as a condition for their annexing this property.
Right.
They didn't have to annex it at all.
That is true, but the law...
Your predecessor agreed that as part of the annexation, if they would do it, that the property would not be used for any purpose other than what was already permitted in this particular zone, which includes an awful lot of stuff. Hotels, motels, all kinds of things.
Right, but the problem is when the county makes the decision to expand the uses in that area, then the
You're
city...
stuck with your covenants.
What your predecessor should have done is entered into a declaration of covenant saying the only uses that will be allowed on this particular piece of property are the uses that the county zoning code explains. Then you'd have what you wanted.
Well,
Then as the county zoning code changed and gave you more uses, you'd get them, but that's not what you agreed to.
and I think that would
I
have
don't
complied
mean
with the
you, I
law.
mean the predecessors.
I understand.
Years ago.
But I think that what Your Honor just said would comply with the law, and I think this
Yeah, but
doesn't.
suppose then the county downzoned, then you'd be in real trouble.
That, again, the county should be making these decisions, not the
County's not
municipality.
complaining about it. County's not a party in the case, is it? The
No,
county's
Your
not complaining, they don't care if the property is more restricted. What zoning authorities generally want is to make sure that the properties are at least as restricted as the zoning code requires. And so the county's not going to complain about it. They probably wouldn't have any standing to complain about private covenants.
Well, again, I think from a policy standpoint, you don't want the municipality making these decisions and in a position where it can say, all right, you can do this, but you can't do that. But let me put the zoning issue aside for a minute and talk about the other, what I think is the other dispositive issue, and that's the issue that was addressed by the Court of Special Appeals, and that is, should these covenants exist anymore because of their purpose, and can their purpose be fulfilled? I don't think there's any question.
We're not talking about whether the covenants today, in light of whatever contemporary circumstances are confiscatory?
No.
Okay.
No. Can the purpose for which the covenants were enacted come to fruition? I don't think there's any question. The answer is no.
Well, but in making that argument, as I understand from the brief, you're restricting the purpose to the University of Maryland putting a science center on there.
That's what the annexation agreement says.
Well, that's what was anticipated, but of course the covenants permit an awful lot more than that.
Well,
They permit anybody to put anything that's within the scope of the covenants on there.
I don't see them as expansive as Your Honor, but the fact is, the purpose of the covenants was to have the University of Maryland Science and Technology Center, which for 15 years before MIE came along, did not get developed. At about that same time, the University of Maryland said, we're out of here. Not only has nothing been done, it's become a financial drain on us, and we don't see any development on the horizon.
It's really, we're confusing a little bit the distinction between the words purpose and reason. The reason you have the covenants is that was what was going on with the University of Maryland. That's the reason you have the covenants. And the purpose that the University of Maryland was doing and the city is doing it doesn't necessarily mean that the covenants are going to be unenforceable if the original purpose that the parties had in mind changes. You made them run with the land, and that's the big problem. You put covenants out there to run with the land, I'm not even sure, without all owners of this property, and we've been told there's at least one other owner who's not a party to this case, whether if we were to rule that these covenants don't apply, how it would in any way bind that person, how you'd ever clear up title on that person's land, because he'd have a piece of property. He wouldn't have been a party to this case. I'm not sure we even have all necessary parties in order for us to void the covenants if we were to choose to do so.
I believe at the time of the sale, this case had already, the circuit court case had already been decided, so I think the subsequent purchaser would have taken subject to
Whatever that
this existing court case.
Johns Hopkins University or the National Institute of Health wanted to put a science center on that property. Would that be consistent with the covenants as you see them? Not the University of Maryland.
Assuming you're substituting another university.
No, all right. Forget the university.
Okay.
Let's assume it's the Defense Department. Let's suppose it's IBM. Anybody
drug company
wants to put a science center there. Is that consistent with the covenants in your view?
Arguably, it would be consistent.
But arguably not?
Arguably not, because if the intention was to have a university, even if you put aside it was the University of Maryland.
But the covenant said the name could change. They weren't holding the University of Maryland.
Right, but that doesn't necessarily mean that they don't want the University of Maryland. If they wanted to allow some different name down the road for marketing purposes or whatever, that's not unreasonable to allow them to change the name. But I think it is a very large distinction to have a non-university science and tech center because that was the vision. I mean, this whole concept was conceived by the University of Maryland. It was their baby. They brought it to the table. Eventually, it got adopted. They worked on it, but nobody could get anywhere for 15 years, and the university gave up. The fact of the matter is, nobody is knocking on the door and saying, hey, we want to put a science and tech park here. And that's why I was equivocal on answering Your Honor's question, because, yeah, arguably, if IBM wanted to come in and say, I want a tech park here, yeah, that probably works. I'm not sure it technically complies, but I don't think anybody would argue with it. The fact is, IBM is not knocking on the door. Nobody's knocking on the door.
What you're basically saying is that if speculation pressures change, and the thoughts of speculators as to what can be done with the property prove not to be correct due to circumstances beyond their control, within their control, that you ought to waive the covenants. And I don't know that to be the law.
Well, I think the law is if the purpose can't be fulfilled, or if the circumstances have changed, then the covenant shouldn't be enforced. Let me flip it around. The questions that you're asking me are all directed towards, well, why shouldn't they be enforced? Let me flip it around. Why should they be enforced? The purpose has failed. What good does it serve to say you can only have these, 15 uses or whatever on the property? And the reason that I flip it around is because if you're not getting a science and tech center of any kind, and you're certainly not getting a University of Maryland science and tech center, what sense does it make? And what benefit is it to the city?
Well, isn't it their call? I mean, if the uses are legal, lawful, under the covenants as they are, and as Judge Harrell asked, it's not confiscatory to insist on them, that the property can be developed within the covenants, aren't they for the city's benefit? Why isn't it the city's call?
Well, I would submit that the covenants weren't able to be developed under the strict covenants.
You would, your predecessor, your client's predecessor, could easily have protected himself merely by in the declaration of covenants saying, if it is not developed as a University of Maryland Technical Center within 10 years, 15 years, 20 years, 50 years, if it's not done, then the covenants will become null and void. And I don't recall that in what I read.
That certainly could have been in the document, no question. But I think the restatement...
If your client didn't protect himself, why should the court protect him?
Good question, and I think the restatement provides a good answer to that. And I'll paraphrase it while I'm looking for the quote. But basically, it said that parties can't anticipate every contingency. And that's why courts need to look at the issue when it comes down to a situation where the purpose is not being fulfilled. You don't have to have it in the contract, and that's why the city argues so strenuously to restrict the inquiry only to the four corners of the document. The Pollock v. Bart case makes clear that you look at parole evidence. You don't just look at the documents themselves. And the restatement, it was section 7.10 of Restatement Third of Properties, it says, potentially unlimited duration of servitudes creates substantial risk that absent mechanisms for non-consensual modification and termination, obsolete servitudes will interfere with desirable uses of land.
How many years are we talking about? What, 22, 25 years here? So since the covenants were created? When were the covenants created? I forget.
86.
1986?
Correct. So we're over 20 years.
21 years.
Right.
I was trying to look through my memory this morning when I was going over this case again, and I can't recall cases in which time has played an important part in the termination of covenants when the time is as short as 21 years? Can you enlighten me? I beg to be enlightened. I just can't recall. Doesn't seem to me to be very long in terms of property law.
Well, I think that timing isn't the only dispositive issue. I think when you couple that with what was happening during that time, you had, and we cite this in the bullet points in pages 18 through 20 of our brief, you had a period of explosive growth, probably unparalleled growth, both in the D.C. suburbs, so geographically, but also in the development of tech parks. And if this tech park, given its location, given the university affiliation, given the inflow of jobs to the D.C. metropolitan area, and given the proliferation of tech parks, if it couldn't happen during that period, and now the University of Maryland has walked away, and not only has it walked away, but it's developed its own tech park in College Park, then when is it going to get developed? The answer is it never will. And granted, in the scheme of things, and particularly land use, 21 years may not be the longest period of time. But
Never is normally defined as 21 years.
But if it doesn't happen in this absolutely prime location and prime circumstance, what are we waiting around for?
Aren't you, you're focusing on the, I gather, the obsolescence of the servitudes, yes?
Yes.
Okay. Aren't you inviting us to second guess the battle of the experts that took place in front of Judge Houghton?
No, Your Honor.
She was presented evidence from the city's perspective by its experts, planners, economists, what have you, and you had yours. And they generally said, oh, they can develop this property just fine under those covenants. And you said, no, we can't. And she chose to believe their experts.
Well, again, as the Court of Special Appeals pointed out, what the judge was focusing on was whether there was a possibility. The real standard is whether it's reasonable. Whether it's reasonable under the circumstances. And in looking at the circumstances, you have to look at
whether what's reasonable.
Whether it's reasonable to continue to enforce the covenants.
Even if everybody agrees the covenants were reasonable when enacted, then you're really talking about the waiver. Have they been waived because it's no longer reasonable to have them? Or has it been waived because there are other uses in there? And it's my understanding almost all the uses in there are uses that would fit within the covenants.
Well, I don't think the city has taken that position, actually. I mean, in addition to the dance studio.
Well, I read all that list of things, and then somewhere
Yeah, you
here
know,
I
it's
remember.
interesting. The dance studio isn't in there, but reducing salon is.
What's that? I didn't hear
Covenants
you.
permit reducing salons, whatever they are.
Right. I mean,
Yeah.
Seems to be a little artful use of naming the business like I've avoided this massive case.
but again, I don't think the city would argue that we're on our way to a science and tech park. The covenants themselves, there may be some tenants in there that come within the covenants. There are tenants in there that the city has taken the position do not come within the covenants. But regardless, we're not moving towards a science and tech park. So if we're not moving towards a science and tech park, why do we have these restrictions at all? What purpose are they serving? Is it reasonable? And the answer is no, it's not reasonable, because you're just having these arbitrary uses with no direction. I mean, Judge Cathell, you raised the question, is it waiver? It is waiver, but it's not only waiver. Talking about whether or not the purpose still can be fulfilled, or whether it's reasonable to still have these purposes, is slightly different than waiver. I think some of the indicia are the same, but it's slightly different. Why do we have it? Why are we restricting development? Why are we letting the city choose as opposed to the county when it rezones. The waiver issues are specifically,
That confuses things. Counties rezone, cities rezone all the time. It really don't have anything to do with private covenants. And zoning people really don't very often consider private covenants when they're getting into their 5-year rezoning or whatever the heck it is. They zone it the way the county wants the business, and if there are covenants that restrict it further, the counties don't care. If there are covenants that allow you to do more things, counties do care because they're going to stop you from doing the things that aren't permitted by zoning. So we keep talking about the county. Number one, county, as far as I know, is not in the case. And I can't ascribe to counties generally your characterization of what, quote, they want. Most of the time, they don't know what they want to begin with.
well, the legislature...
Depends on every 4 years when one bunch of rascals is kicked out and another bunch gets in. As to what they want.
The legislature...
Public servants, I'm sorry.
The legislature has said it's the county that decides whether the county specifically has an interest or not. It should. It's the one that is designated to have this power and is to try to keep everything uniform.
You wouldn't argue, could you, would you, that the county had any standing at all to enforce these private covenants? The county, no.
The county would not. I would not argue that. But again, so it's one issue whether or not these covenants have expired, whether they've failed for their purpose. It's a separate issue, although related, whether or not there's been a waiver. And on the waiver, I mean, there are several points, including representations made to MIE that the covenants wouldn't be enforced, the fact that it began building its standard flex buildings and everything was going along swimmingly until the city asked for a specific type of office building, which MIE said, we're not ready for that, the market's not there for that. After that, that's when the city threw a fit. That's when it started enforcing the covenants. That's when it started saying, oh, you have to tell us what you're going to do with this. And that's when it filed the lawsuit. And so that's why I say that this is not something from a policy standpoint that we want to have happening. If there was a possibility, and this is where I think the Court of Special Appeals was coming from, excuse me, not a possibility, a probability. If there was a probability that this could be a tech park, that the original vision of the parties could come to fruition, okay, well, then it's worth doing. Or at least it's worth giving it 21 more years, or whatever. But we have a situation here where it's not happening. The University of Maryland's gone. And all you have, you had virtually no development until MIE came along, and then MIE began engaging in its standard flex buildings. It started to develop. It's not a tech park. It's not going to be a tech park. So why continue these covenants?
Counsel, putting aside a remand for the taking of additional evidence, is it your contention that the record as it was made before Judge Houghton, she would be unable to make a finding that it is probable that this property could be developed consistent with the covenants at some prospective, reasonable future date?
That it's probable that it would be a tech park? Yes.
No, not tech park. In accordance with the 15 listed permitted uses.
I don't know that the record, I don't know that I would go that far, but I would.
Well, then if you can't go that far, and you're not back on remand for the taking of additional evidence, what's the point? What kind of Pyrrhic victory are you arguing for here? Send it back, let her look at the record that she had before her, and if she still chooses to find, we say, oh, you applied the wrong standard, it had to be probability. And she says, I looked at the record, I believe the city's experts, it is probable. And therefore there's substantial evidence in the record before her to support that conclusion, since you appear to be saying, well, she isn't legally foreclosed from making that conclusion because the record is so wholly deficient in evidence to support it. What's the point of all this?
But it's still the wrong question. The question is, Your Honor said not a tech park, the uses. That's not the question. The question is, what was the purpose of the covenants? And the purpose of the covenants was to develop the tech park.
That's what this case, from your perspective, is all about, is it
Yes.
not?
Yes.
That what she would have to find is that it is reasonable to find that a tech park with the University of Maryland is probable. That's the point you're making.
Yes. Either with the University of
It has
Maryland.
nothing to do with the other covenants,
Correct.
what they say.
Correct.
That's okay.
With the University of Maryland, or even arguably without the University of Maryland. It's just not going to be a tech park. And ironically, the trial court did find, as a matter of fact, that was that's what the parties intended to do. The court said at E 2091, trial court found that the parties expressly intended that the subject property be developed as a science and technology research park with supportive uses, and envisioned that the University of Maryland would lend its name and research affiliation to the site. What the court didn't do, and what the Court of Special Appeals said was error, was that it didn't analyze that as the purpose of the covenants. So even using the city's argument, we're looking at the four corners of the document, that's the purpose. That purpose can't be achieved. And so whether or not, hypothetically, you could have a successful development of this large parcel of land just using what was in the zoning code, or some of the things that were in the zoning code back in 1986, that doesn't make a whole lot of sense. And it really unnecessarily hinders development, because you're not heading towards any meaningful goal. Why should you be limited to those things? Intellectually, I can understand why you'd be limited to certain things if you had a specific goal, like developing a tech center. But if you don't, why do you have these arbitrary, this is in, that's out? It doesn't make any sense.
Did you proffer, whoever was trying the case, proffer to Judge Houghton that you wanted to put on evidence about why your predecessor in title wanted to be annexed into the city of Bowie and execute these covenants after they had gotten the zoning from the county for EIA?
I don't know if there was a proffer on that specific issue. I know that there was an attempt to introduce testimony and evidence about what was the purpose and what was the expectation on the front end. I don't know that there was a proffer, but I know that there were attempts made to introduce evidence to that effect. There's one other issue that we had raised in addition to the zoning and the waiver, and that was the necessary party issue. I don't think a lot has to be said on it. I think it's pretty clear that the dance studio had an interest in this case, and that interest was, very meaningful to them, not being able to operate their business anymore.
Well, what is your view of the law on that? They apparently, according to the city's brief, were offered an opportunity to come in if they wanted to, and chose not to.
That the dance studio was...
Are you saying they had to be made a party, even involuntarily?
Well, I think the city needed to sue them as a party. I think the city needed to sue them, and they didn't. And the dance studio didn't have its day in court. So,
would the worst of that be that they wouldn't be bound by the decision of this court?
I think they are bound. I mean, there's an...
Presumably they could argue because they weren't made a party, they're not bound, and so they can continue to operate the dance studio. Not the worst of it?
But that's not how the court's injunction reads. If the trial court is ultimately upheld. So in conclusion, what we're urging the court is that the covenants failed. They serve no purpose to go forward. They should be declared void. They should also be declared void based on the zoning issue that we discussed earlier.
Your position is they ought to be declared void, but you can't say they failed because they kept you from building the property. Covenants did what they were designed, what their language was designed for them to accomplish.
The purpose of the covenants for which they were enacted failed. Thank you for the clarification. If the court doesn't declare them void, we would request that this court remand the case in accordance with the Court of Special Appeals opinion, with the modification of adding the dance studio as a party and allowing MIE to present all of its waiver evidence, not just the waiver evidence going forward from the last trial, but all of its waiver evidence.
Thank you, sir.
Thank you, Your Honors.
Ms. Levan?
Thank you, Your Honor. Okay. I just want to address a certain number of points raised by Your Honors with respect to counsel's argument. Judge Cathel's hypothetical that had the original parties used the phrase that the property owner could put whatever was permitted by the existing zoning on the property would in fact have gotten them what they wanted, but it wouldn't have given the city what it wanted, which was certainty about the development of this property. Because of the nature of zoning authority in Prince George's County, the city would have known all along that the property owner could always get a change in zoning from the county over the city's objection, and that is in fact what has occurred, and that is why this isn't about a municipal temper tantrum. That's why this is about bigger things. The new comprehensive basic plan that was approved by the Planning Commission while this case was being briefed includes 866 units of residential development. So it thwarts what the city wants to do with this property, and we have to keep in mind that this 466-acre tract is one of the last tracts of that size.
What the city wants done with this property.
I'm sorry, yes.
Not what the city going to do with the property.
Exactly.
Not the city's to
What
do with it.
What the city would like to see done with it is high-quality employment. And there aren't a lot of parcels that have this opportunity, certainly in Prince George's County, in northern Prince George's County. And so the city has quite a strong interest in seeing that the covenants remain in effect.
State's the general public policy of this state, if things are a little muddled, that we choose a position that comports with the free alienability of property. The public policy of this state is to encourage, to the extent legally possible, the free transferability of property to keep the property market. It's always been that way for 200-300 years in this state. How do you address that?
Well, I think that states an accurate proposition. However, the cases are very clear that with respect to covenants, that rule has given way to, and Your Honor said specifically.
The last thing we fall back on is the free alienability, the free transferability of property as being a valid and good public purpose. Now, I don't know that it's ever really been done in 21 years. That's something you might look at 90, 100 years down the road when other people are sitting everywhere other than us.
That's certainly possible. I would say that the lapse of time that has occurred is insufficient to conclude that there is really any restraint on the alienability of this property. Obviously, they've transferred one property. They're likely to transfer additional parcels from this property to business owners. And there hasn't been any showing at all that the covenants are preventing that from occurring. Council thinks that the purpose can't be brought to fruition, but the purpose is coming to fruition as we speak. There's a 4-story office building that's 70-something% leased at this point, and there are permits out for additional ones. This property is being developed by this property owner right now in accordance with the covenants.
Wouldn't the covenants, if strictly applied, kind of limit the marketing of that office space? You couldn't just go out and, have all the insurance companies in the world have their adjusters take space in there.
The way the covenants have been interpreted actually general office space is viewed as complying with the terms of the covenants.
Notwithstanding that it
by
says
both-
it's supposed to be research and medical and yada, yada.
I think it also says in administrative offices, and so.
Could you have law offices, could lawyers have offices in this
Not
business
at,
park?
not at present, although I believe that the Class A space that's just been built would be suitable. I don't believe there are any there now, and in fact, I think it's
This
a,
question is, could they?
Could they be? Could lawyers? I mean, I'm not saying maybe, it might be a good thing not to have them there. But, could
Means you would have
lawyers?
to do some research if you're there.
Yeah, that's true.
I don't know the answer to that question, Your Honor. I do know that a tech business has taken most of the space in the new office building.
A test business?
A technology business. Or a
Whatever that
science.
means.
I just didn't understand the young lady.
Counsel suggested that the change of name from the Maryland Science and Tech Center might be accomplished for reasons other than the withdrawal of the university, such as marketing. But their entire point is that the marketing of this property required the university. So I think it's disingenuous to suggest that they might change the name of the property if the university was so critical to marketing, because it would be better to market it without the university. And I need to be clear that this, contrary to counsel's argument, this was not the university's baby. It never was the university's baby. The university was never a property owner. The evidence established that they never promised to establish a presence there. It was the University of Maryland Foundation. The property was a gift to the foundation, and the foundation had to decide what to do with this asset. And ultimately, it decided that it was in its mission to sell it and use the capital to do something else. But it wasn't the university. The university said we were only there to attract economic development, which is exactly what the city wants to attract. The Pollock case mentioned by counsel does not say parole evidence should be admitted on the question of the meaning of the document. It says parole evidence should be admitted on the change of circumstances, and I already addressed the distinction that the cases make on those 2 points. Counsel mentioned that this was the time when the property was not being developed, the 14 years it was held prior to MIE's acquisition, was a time of explosive growth for this kind of development, and therefore clearly the property can't be developed in accordance with its original vision. But you got to keep in mind that the developers during that entire period were insolvent. So you can't really say that a properly situated developer couldn't have taken advantage of those market conditions. And it's unfortunate that market conditions have declined a bit since then, but market conditions being cyclical, you also can't say that next year or 5 years from now they won't return to that kind of explosive growth, particularly given the relative scarcity of land that's becoming.
Did your experts so opine?
Yes, Your Honor, they did. And one of the reasons that the court chose to believe the city's experts on that point was that, in fact, the defendant's experts agreed. And I referenced that in my brief, and what happened was we were sitting at deposition, and we'd gone through his whole expert report, and I handed him the covenants, and I said, tell me what about this list of uses inhibits the development of this property? And he looked at it, and he looked up, and he said, I don't see anything in there that inhibits the development of the property. And I was stunned. But he said, I don't think those are the covenants. But they were.
Yeah,
and
but
so
the
that's why they need a new expert testimony.
It's pretty clear they don't allow them to go in and build a 1,000 unit or a 500, whatever it is, residential development.
Exactly.
And of course, if they could do that, it would make the property more marketable. I think anybody would agree that, especially, I'm sure this is outside the record, what's happening in the military community with all these jobs and new positions and laboratories and things coming, that the more uses you have for a property, generally the more marketable it is. Sometimes if it's a wrong usage, it may hurt you. You have to be careful.
Well, I think that we can assume that the developer has an economic reason for wanting the covenants to go and put residential on this property. So I'm not going to argue that that wouldn't be profitable for the development. I just don't think that's the dispositive issue, and I don't think that being restricted to commercial development makes the property undevelopable. And I think that the experts expressly said that. And in fact, their experts' entire point was that the university was necessary to commercial development, not to the mixed-use development they apparently want to put on the property now. Okay. As to the necessary party, I want to be clear that, I'm sorry, is my time up? I apologize.
Got a minute.
I want to be clear that, to my knowledge, the city did not go to the dance studio and say, please be a party. Our position is that they participated, that they were represented by counsel.
I'm not worried about the dance studio. I'm worried about the other property owner that owns property in here not being a party. I don't think merely because they took, knowing that this lawsuit was going on, really, if we were to decide the other way, would suffice from a title point of view. I'm just concerned about the title to that tract of land would not be necessarily affected by this piece of property. A title examiner, in other words, when he examines that piece of property, I guess he'll come back in the chain. I don't know whether he would get this case or not. That's
I'm fairly certain it did transfer after the circuit court's decision, so if you affirm, there's no problem. There were no representations made to MIE about what was going to happen with the enforcement of this covenant. That's that's imaginary, and I guess I'll leave it at that because I think my time is up.
Thank you all.